Well, hi everyone. Sean Humphreys here. Welcome to All Things Retirement. Well, in this installment, we're going to do a bit of an estate planning discussion with Krista Glendenning, who's a lawyer who specializes in will and estates and estate planning. For contact information for Krista, you'll find it in the show notes. So the question I have for Krista today is, what happens if you can't find your will? Believe it or not, this happens from time to time. So again, if you're interested in estate planning, if you're an executor, you'll find this discussion helpful. Now, if you're new to our channel, make sure you hit the subscribe button. We're posting content all the time on various aspects of retirement income planning and overall wealth planning. So if you don't want to miss future content, hit subscribe. And if you like the video, make sure you click like. Okay, let's listen to Krista's comments about what happens if you can't find that darn will. Well, thanks for making time, Krista, for our discussion today, another estate planning topic. And maybe a kind of a funny topic, but a lot of people put time into working on their will and the estate plan. They get it all drafted and documented. And unfortunately, life has its twists and turns. And all of a sudden, there's a need to review the will or even use the will in an estate planning context. And they can't find the original will. They have no idea where it is.
Yeah.
So I suspect in your practice, you've heard of stories like this. So what does a family do? What does a person do when they need to use the will and the one that was drafted cannot be found?
Yeah, so I think you're in two different situations. If it's a situation where you're just looking to update your will, revise it, in that case, you're in a much better situation because you're able to, even with a photocopy, take a look at that document. Ultimately, you might be looking at re-executing that document or updating and signing a new one, assuming you're still competent to sign a new will. But you're in a much more sticky situation if you've lost the will and the person has passed away and your original can't be located. So it does depend. You can admit a photocopy potentially, but there's no absolutes to that. It's up to the court and their discretion to decide to approve a photocopy of a will. And typically, if you're an executor named in a will that has been lost, but you have a photocopy, you will be required to give some additional evidence to the court about why it was lost, the circumstances. You're basically also trying to prove as best you can or give evidence to the court that the deceased didn't revoke that will or destroy it intentionally with the intention of having it no longer take effect. There's some interesting presumptions that exist at law that depend on capacity of that deceased will maker. And if the person had capacity up until the date they passed away and the will has gone missing, there's a presumption you generally have to overcome that they must have destroyed that document or done something with it intending to revoke it because it can't be found and they had capacity.
Oh,
And then,
okay.
yeah, and then vice versa, if the person lost capacity, you're actually in a better position because the presumption is they did something with it in their incapacitated state and they didn't have the ability to revoke it at that point. So the photocopy is easier to admit in those circumstances. But either way, as an executor, you have this additional burden of proving to the court what happened so they can rely on your evidence and then hopefully approve that photocopy in probate.
But if you have no photocopy, you can't, if you have nothing, then your only recourse is to have, are you technically died intestate or what's the situation then?
Yeah, so I mean, if you don't have any form, any copies, anything of this will that hypothetically existed, you're going to have a very difficult time getting anything admitted. Like you have to have a will in writing generally to provide to court. There is this thing that's happened a couple times. There's a couple interesting cases which we refer to as phantom wills. So some interesting scenarios that have arisen where there was a written will. And for example, like at a funeral, this will is passed around, but then it goes missing. So I don't know if someone's taking it and destroyed it. Someone didn't like something that was in there, but there was enough family members there that saw the will and read it that they could give evidence to the court and actually like put together a will by court order because so many witnesses had seen it. So that's a very rare situation, but one that could come up. Yeah.
So I guess the takeaway here is don't misplace your will. So
yes.
So what do you have any recommendations for how people should do this whole safekeeping thing? What the protocol should be so we just don't get into this situation?
Yeah, so one of the things I like to do with every will package I prepare is a one-page location document that confirms where my client is planning to store their originals. So whether that's in a safety deposit box at a certain branch location, in a fireproof lockbox at home is also common. Apparently, another place that people look for wills is freezers. I guess it's like a fireproof location as well.
Oh,
So
really? Okay.
sometimes people find them in freezers. I've never had that
Yeah.
come up with any of my clients, but so another interesting place to look. But basically, just keeping them somewhere safe, ideally somewhere fireproof or that they'll be protected in the event of a disaster. And making sure your executors or other family members that need to know where to find those documents know the location, and if they need a key or a code, that they have access to that as well.
Okay. So if you don't have the original signed will with all the, the signatures and the sign-offs, but I typically, I know with your firm, if you help clients get a will done, I suspect you've got the PDFs of the will on your system. But you're back to the same issue. If you generate a copy from your system, but it's not signed, you're back to some of the original issues or problems that you outlined at the beginning of our discussion. Or is there an additional weight if the lawyer can say, well, listen, we drafted the will, they executed the will in our offices, we can vouch for the fact that that was done. Does that make any difference in this scenario?
Yeah, you're going to be in a better position if you have a signed copy, but certainly it has come up where all that seems to be circulating is a unsigned copy, but exactly what you're saying. So you would have to be able to prove to the court that that document was signed, that you had the two witnesses sign. There's another requirement we have in Manitoba. You need an affidavit of execution signed by one of the witnesses to the signing of the will. So that would be another piece you need. So I think it's just the more you haven't met the criteria to have a valid will and the original valid signed will, the more evidence you're going to have to give the court to try to get it through.
Okay. Now, is there a difference between, so if I've got a signed will, I've got the hard copy of the will, all the signatures, all the documentation, I've got the affidavit, and I scan all those documents, it's just a copy of a signed will. Is that still valid, or is that treated by the courts as not a valid will because it's not the initial or the original signed hard copy document?
Yeah, they want the signed original. So there should be one and only one original that's executed here for a Manitoba court, and that's the one that goes to the court. And if it's anything other than that, any photocopy, PDF copy that you're printing off, it's going to have these additional requirements of evidence giving, of explaining where the original went or why we don't have it.
And it's interesting in the world that we live in today, which is so much digital, where more and more documentation is done electronically, that there's still that requirement. Do you see a day where digital documents would be valid at some point for estate settlements, that kind of thing? Is there any discussions going on by law societies and the legal area around this?
Yeah, I think probably wills will be one of the last areas to take it on. So I don't see any incoming change in the near future. What they have brought in since the pandemic struck us is video execution. So we can have your
Oh,
witnesses present by video conference.
okay.
So that gives us a little bit more flexibility, but your physical paperwork, the physical will you're signing still has to be the original with your client, sent back to the lawyer or the witnesses to have their signatures added and the affidavit signed and all of that. So that it gave a little bit of flexibility in that way, but we still are dealing with physical originals as far as I expect going into the future for now, at least. But I imagine, we should be heading into a technological future that brings some changes, but who knows? It's a
Yeah.
slow area of law for sure.
Yeah, it's not at the top of the list right now in terms of those
No.
kind of priorities. So I know you really pride yourself as being a coach to your clients around estate planning, but also responsibilities as executors and powers of attorney, and you want to stay engaged in that kind of conversation with your clients. How common is it for clients who execute their will, got the signed document, and they say to you, Krista, can your firm vault this will, just hold it for us, so that if it's ever needed, we know where to get it? Is that happen very much, or is that uncommon?
So I think, historically it was much more common for lawyers to hold wills, and it was something that Lawyers actually did more so to try and get the administration work back in the day. But in today's world, our law society doesn't want us holding originals.
Okay.
So we're supposed to, unless there's special circumstances, we are supposed to give them to clients to have a storage plan for themselves. Only in special circumstances, and it's more so things where we have family members influencing the will maker, perhaps. So we want to protect those documents, and we have special directions not to release them until the person passes away, and not to release them to any family members or even to our client by mail or something, just because we're so concerned about those getting into the wrong hands early. So that would be the limited situations where we will keep them at the firm to protect them.
Okay. Well, that's a great overview, and I guess, like I said, the takeaway here is make sure you have it in safe storage. You know where it is. Probably want to let family members or at least your executor know where it is, and so if it's ever needed, it can be easily found and used if it needs to be used at that point in time. Thanks so much for addressing this question for us today.
No problem. Anytime.
Well, it's my hope that you found this conversation helpful. So again, if you're looking for estate planning expertise, make sure you reach out to Krista. If you need to have your will and estate plan updated, contact information for Krista is in the show notes for this video. As well, if you're within 5 years of retirement, or maybe you're already retired and you'd like a second opinion on your current plan, there's a link to our website where you can find out how you can get a complimentary retirement income planning analysis. Again, if you don't want to miss future content, hit subscribe. And if you like this video, make sure you click like. Wishing you all the best in your retirement and overall wealth planning journey. You take care.